Hello and welcome to Byju's Exam Prep IAS. Let's get started and look into our daily quiz. Before we start with our practice questions for the day, we have a quick gentle reminder. As part of our weekly current affairs session, today's topic would be Enforcement Directorate Reach. Please do tune in live on our YouTube channel at 8 p.m. so that you understand everything about this topic. Let's get started and look into the first question. Which amongst the following statements is not correct with respect to Comptroller and Auditor General of India? CAG complies and maintains accounts of both central and state governments. CAG can audit all transactions relating to the contingency funds. CAG submits audit reports relating to the accounts of the central government to the President. The CAG is appointed by the President and can only be removed from office in like manner and on like grounds as a judge of the Supreme Court. Which amongst these statements is incorrect? The answer to this is CAG complies and maintains accounts of both central and state governments. This happens to be the wrong statement. Why have we taken this practice question? Because this article on the Hindu makes a reference to the Comptroller and Auditor General of India. When we look into the first statement was incorrect. Why? That is because the CAG complies and maintains the accounts of the state governments. In 1976, CAG was relieved of the responsibilities regarding the compilation and maintenance of accounts of the Government of India due to separation of accounts from audit through the departmentalization of accounts. So the first statement is wrong because in 1976 it was relieved of the duty with respect to the central government. But the other three statements are right. Yes, CAG can audit all transactions relating to the contingency fund. Yes, CAG submits audit reports relating to the accounts of the central government to the President, and it is the President who puts it before the Parliament. And finally, if the CAG has to be removed, the procedure is similar to the grounds as similar to that of the judge of the Supreme Court. And do note, we already have a video with respect to the CAG where an elaborate discussion has been taken up with respect to the knowledge series, so kindly look into it, and the link for the same will also be given in the description box. Now let's look into the next practice question. Consider the following statements. Among the union territories, Delhi alone has a high court of its own. Parliament, with the previous consent of the state, may by law extend the jurisdiction of a high court to or exclude the jurisdiction of a high court from any union territory. Which of the statements given above are correct? The answer to this is none. Why have we taken this practice question? Because this article on the Hindu makes a reference to the High Court. Let us try and understand what are these options. When we look into the first option, among the union territories, Delhi alone has a High Court of its own. This statement would have been right until 2019. But what happened in 2019? There was a major change where the state of Jammu and Kashmir was ultimately turned into a union territory. Now we have the union territory of Jammu and Kashmir, which also has a high court as well. So among the union territories, we have Delhi, which has a high court, and we also have the union territory of Jammu and Kashmir, which also has a high court as well. So it is not Delhi alone, but we also have Jammu and Kashmir, which is why the first statement is wrong. When you look into the second statement, Parliament, with the previous consent of the state, may by law extend the jurisdiction of a high court to or exclude the jurisdiction of a high court from any union territory. This statement is once again wrong. Why? Because the Parliament need not have to take the consent of the state. If you look into Article 230, it states Parliament may by law extend the jurisdiction of a high court to or exclude the jurisdiction of a high court from any union territory. So the consent of the state government is not required for this, and the Parliament would be able to do on its own motion. Where the high court of a state exercises jurisdiction in relation to a union territory, nothing in this constitution shall be construed as empowering the legislature of the state to increase, restrict or abolish that jurisdiction. So whenever a high court in one of the states also has the jurisdiction of another union territory, in that particular case, this high court, wherever it is situated, its legislature will not be able to increase, restrict or abolish that jurisdiction, and that power is only given to the Parliament. So it is the Parliament alone which would be able to extend the jurisdiction of high courts to the union territories, and they need not have to take the consent of the state government. Now let's look into the next practice question. question. Consider the following pairs. We have freedom fighters on one side. We also have the tribes that they belong to on the other side. Tilka Maji, Pahadiya tribe. Talakal Chantu, Kuruchiyar tribe. Buddha Bhagat, Orayon tribe. Ragoji Bangre, Mahadev Koli tribe, and Lakshman Nayak, Bhuvan tribe. Which of the above pairs are correctly matched? The answer to this is 1, 2, 3, 4, and 5. Why have we taken this practice question? Because this article on the PIB makes a reference to the freedom fighters who were the tribals and they also contributed to India's success. So this article says that these are the people who are not cherished, these are the people who are not remembered. So it is time for us to remember these tribal leaders who fought for the glory of India and have shed their blood for the country. We have Tilka Maji, who rebelled against the atrocities of the British East India Company. He mobilized the Pahadiya tribe to which he belonged and raided the company treasure. He was hanged. Talakal Chantu of the Kuruchiyar tribe was an invaluable part of the Palaji Raja's war against the East India Company. He was hanged by the British. Buddha Bhagat of the Orayon tribe was shot down in one of his many encounters with the British, along with his brother, 7 sons, and 150 men from his tribe. Tirot Singh, who happened to be a Kasi chief, realized the duplicity of the British, waged war against them. He was captured, tortured, imprisoned, and he died in prison. Ragoji Bhangre belonged to Mahadev Koli tribe. He revolted against the British, continued his struggle even though his mother was imprisoned. He was captured and hanged. Sidhu and Kanhu Murmu from the Santal community revolted against the British and their stooges. They led the Santal in the Hul rebellion. Both were betrayed, caught and hanged as well. Rendo Maji and Chokro Bisoi. Then we have Ramji Gond of the Gond tribe. Then we also have Telanga Kharia of the Kharia tribe. Tantia Bill, also known as Robin Hood of the Central Provinces. Then we have Major Payona Brajabasi of Manipur, Birsa Munda of the Munda tribe, Matmur Jamo of the Adi tribe of Arunachal Pradesh, Thana Bhagat of the Orient tribe, and Malati Mem of the Tea Garden community, who was inspired to join Mahatma Gandhi Satyagraha movement. She went against the British monopoly over the opium and educated her people about the dangers of opium addiction. During an encounter with the police, she was also shot dead as well. Then we have Lakshman Nayak of the Bhuyan tribe, who was also inspired by Gandhi and campaigned extensively to get tribes to join the freedom movement. Helen Lapcha of the Lepcha tribe was an ardent follower of Mahatma Gandhi. Then we have Pulimaya Devi Podar, who heard Gandhi when she was in school and wanted to join the freedom struggle immediately despite stiff opposition from her family. She joined the movement after her studies and encouraged women to join her. These are some of the men and women who contributed to India's success and fight against the British. Now let's look into the next practice question. With respect to NavIC, which of the following statements are incorrect? It can help in navigation on land, air, sea, and also in disaster management. NavIC satellites are placed at a higher orbit than the GPS of United States. It is designed to provide an accurate position information service to users in India as well as the region extending up to 2,500 kilometers from its boundary. Which of the statements are incorrect? Since it is asking for the incorrect statement, the answer to this is 3 only. Why have we taken this practice question? Because this article on the PIB makes a reference to Indian satellite navigation system, which is nothing but NavIC. When we look into the options, yes, the first statement is right. It can help in navigation on land, air, sea, and also in disaster management. The second statement is also right. NavIC satellites are placed at a higher orbit than the GPS of United States, where the NavIC satellites are placed in geostationary orbit and geosynchronous orbit with an altitude of about 36,000 kilometers. However, when it comes to the GPS satellites, they are placed in medium Earth orbit with an altitude of about 20,000 kilometers. Since NavIC satellites are placed at a higher orbit than the GPS of United States of America, the second statement is right. When we look into the third statement, yes, it is designed to provide accurate position information service to the users in India as well as the region extending up to 1500 kilometer and it is not 2500. Since it is not 2500, the third statement is wrong, which is why this question is asking for the incorrect statement, and as a result the answer would be C, which is 3 only. Now if we have to look into the facts with respect to the NavIC, it is also called as the Indian Regional Navigation Satellite System or IRNSS. It was developed in India by Indian Space Research Organization and its commercial wing Antrix. It consists of 8 satellites located at a distance of approximately 36,000 km. Currently 7 satellites are active, 3 satellites in geostationary orbit and 5 satellites in the geosynchronous orbit. The objective of the NavIC is to provide navigation, timing and reliable positioning system around India. Working of NavIC is very similar to the global positioning system. The NavIC is certified by 3GPP, which is nothing but third generation partnership project. There are two kinds of services that will be provided by NavIC. One is the standard positioning service, the other is the restricted service, which will be for the military, and the system can offer a position accuracy of more than 20 meters within India, which is the primary area of service. Apart from India and United States of America, many other countries also have their own navigation system. What we have is Russia's GLONASS. It provides global coverage. It also has total of 26 satellites. Then we have European Union Galileo, became operational in 2016 with a constellation of 30 satellites. Then we have Chinese BeiDou, Japanese quasi-zenith satellite system. It has a regional satellite system covering Japan and Asia Oceania region, and India, which also has IRNSS, which is NavIC, constellation of 8 satellites. This can also be asked in your preliminary examination. Now let's look into the next practice question. Consider the following statements. The Constitution of India classifies the ministers into 4 ranks: Cabinet Minister, Minister of State with independent charge, Minister of State and Deputy Minister. The total number of ministers in the Union government, including the Prime Minister, shall not exceed 15% of the total number of members in the Lok Sabha. Which of the statements given above are correct? The answer to this is 2 only. This happens to be a previous year question from the year 2022. When we look into the first statement is wrong. That is because it only makes a mention of the Council of Ministers, yes, but it does not make a mention of the Minister of the State or the Deputy Minister, which is why the first statement is wrong. The second statement is right, and as part of the assignment, you have to put on the comment section in which amendment was this statement introduced into the Constitution of India. Please put it on the comment section. Now let's look into the fact of the day. The fact of the day for today's discussion is Maintenance and Welfare of Parents and Senior Citizens Act of 2007. This is also called as the Senior Citizens Act. What is the objective of this act? There are many children who are taken care by their parents. They are also taken care by their grandparents as well. But when it is time for them to take care of their parents and their grandparents, they do not take up this obligation. They do not take the responsibility of taking their parents, in order to make sure that there is a legal mandate where these parents and grandparents are taken care by their children and grandson. What we have is this particular act called as the Senior Citizens Act. So basically, this will provide a legal obligation for the children and heirs to provide maintenance to the senior citizens. So senior citizens who are unable to maintain themselves shall have the right to apply to maintenance tribunal seeking a monthly allowance from their children or their heir. This was initiated by the Ministry of Social Justice and Empowerment, Government of India. So the chief objective behind this law was to make the provision of maintenance and welfare to old parents and senior citizens more effective. This act makes it legally obliging for adult children and heirs to provide for parents by way of a monthly income. Let's look into the definition. If we look into the definition, there are 2 important pointers that we have to look at. Who are the children and who are the parents? When it comes to the children, it includes the son, the daughter, grandson, granddaughter, but does not include a minor. Since it does not include a minor, they cannot ask from a minor. Who is a minor? Any person who is less than 18 years of age will be called as a minor. So because these people would not be able to work, the senior citizens cannot ask from the minor, but they can ask from the children who have attained majority, who are above 18 years of age. According to this act, parents would also mean biological, adoptive as well as the step parents. Under this, there are also provisions to protect the life and property of such persons. Then we have the senior citizen. Who is a senior citizen? Any person who is above 60 years of age will be called as a senior citizen. It is only the senior citizens, that is the parents and the grandparents, who would be able to ask their children, the grandchildren, maintenance on a monthly basis. So a senior citizen, including parent who is unable to maintain himself from his own earning or out of the property that is owned by him, is entitled to the relief under this act. Now there is a question. Can a relative be also asked to take care of the senior citizens? The answer to this is yes. Let's say, for example, there is a senior citizen who is above 60 years of age. After the senior citizen passes away, in that case, the property of this person goes to those relatives, and as a result, if there is this property which goes to those people who will in the near future enjoy the benefits of this property, they can be asked to provide the relief and maintenance under this legislation. So senior citizens who have transferred their movable and immovable property on the condition that the transferee shall provide them basic amenities and take care of their physical needs, refuse to do so, such a transfer of property shall be considered to have been made by fraud or by coercion or under undue influence. Such a transfer can also be made void as well, and abandoning any senior citizen in any place is also a criminal offence. So what should these people do? Such parents or the senior citizens can file an application before the tribunal claiming maintenance and other reliefs from the children or the relatives, and such application will be scrutinized by the tribunal, and the tribunal can also take up a case on a suo motu basis as well. And once when an application is filed in front of the tribunal, this should be disposed of within 90 days, and in exceptional circumstances this can also be extended by about 30 days as well. And during this particular period where the case is ongoing, they can also provide interim maintenance pending the disposal of the case. And once the verdict is given by the tribunal, these children or the relatives will have to provide the maintenance on a monthly basis, and if they do not do so, this will be a criminal offense. They will be imposed with fine as well, and if they do not do so, they can also be imprisoned until they pay the monthly allowance. The act also provides for the state governments to establish at least one old age home in every district of the state, and also ensure adequate medical care for the senior citizens. It is this that we have to understand with respect to this topic. So this is it for today. Thank you for watching. All the best.